Dear students, today we shall discuss about another important act, that is Bonus Act of 1965. In the previous classes we discussed about different types of acts like Factories Act of 1948 and Maternity Benefit Act, then Provident Fund Act, then ESI Act of again 1948. Today we shall discuss the Payment of Bonus Act of 1965. So, this being a very important act, so this is applicable to the workers working in different factories or establishments. Again, we know the meaning of what is a factory. So, where 10 or more people working with the aid of power, or 20 or more working without the aid of aid of power, that such premises or establishments we call as factory. So, to such type of workers, so this act is applicable. Now, before we proceed, let us understand the meaning of bonus. The bonus is a sum of money added to a person's wages or as a reward for a good performance. So, a bonus is a financial compensation that is above and beyond the normal payment expectations of its recipient. That is, bonuses may be awarded by a company as an incentive or to reward good performance. So, this is applicable to every factory and every other establishment in which 20 or more persons are employed on any day during an accounting year. And the establishments to include departments, undertakings and branches, where an establishment consists of different departments or undertakings or as branches, whether situated in the same place or in different places. All such departments or undertakings or branches shall be treated as parts of the same establishment for the purpose of computation of bonus, provided that where for any accounting year a separate balance sheet and profit and loss account are prepared and maintained in respect of any such department or undertaking or branch, then such department or undertaking or branch shall be treated as a separate establishment for the purpose of computation of bonus for that year. And employees of LIC, universities and educational institutions, hospitals, Chamber of Commerce, RBI, then UTI, trade unions, and again financial institutions, social welfare institutions are not entitled to bonus under this act. Usually, the services sector won't come under this facility or this benefit. The eligibility for bonus is every employee receiving a salary or wage up to rupees 10,000 per month and engaged in any kind of work, whether skilled, unskilled, managerial, supervisory, etc., is entitled to bonus for every accounting year if he has worked for at least 30 working days in that year. And the important condition is the salary limit, that is the ceiling of bonus is where any worker he or she is drawing a wage up to rupees 10,000 per month or maybe on daily basis, where it should not exceed 10,000 per month. And salary or wages means all remunerations, so that is other than remuneration in respect of overtime work, which would be payable to an employee in respect of his employment or of work done in such employment, and includes dearness allowance but does not include such OT charges or wages cannot be considered here, and any other allowances which the employee is for the time being entitled to. So, any temporary kind of work, the assignments, any payment made towards such type of work cannot be considered here. And the other important condition is the value of any house accommodation or of supply of light, water, medical attendance or other amenity or of any service or of any concessional supply of food, grains or other articles are also not considered here. Any the facility or benefits other than the monetary you provide, no, so that cannot be considered here, or any traveling allowances, concessions would be included, and any bonus including incentive, production and attendance bonus would be considered, and any contribution paid or payable by the employer to any pension fund or provident fund or for the benefit of employee cannot be considered. Any retrenchment compensation or any gratuity or other retirement benefit payable to the employee or any ex gratia payment made to him cannot be considered. So these are the important conditions for the payment of bonus. Now let us understand the computation of number of working days, because this is also an important criteria to be considered for a worker to be entitled for the bonus facility. An employee shall be deemed to have worked in an establishment in any accounting year also on the days on which he has been laid off under an agreement or as permitted by standing orders under the Industrial Payment, that is Standing Orders Act of 1946, or under the Industrial Disputes Act of 1947, or under any other law applicable to the establishment, or he has been on leave with salary or wages and he has been absent due to temporary disablement caused by accident arising out of and in the course of his employment, and the employee has been on maternity leave with salary or wages during the accounting year. So all these, any such paid leaves also will be considered as working days. And the disqualification for bonus here is, so on the parameters like an employee shall be disqualified from receiving bonus under this act if he is dismissed from service for fraud or any kind of indulging his involvement in fraud or any criminal activities, or riotous or violent behavior while on the premises of the establishment, or theft, misappropriation or sabotage of any property of the establishment. So on these grounds a worker may be deviated from payment of bonus. Now let us understand the deduction of certain amounts from bonus payable under the Act. Wherein any accounting year an employee is found guilty or of misconduct causing financial loss to the employer, then it shall be lawful for the employer to deduct the amount of loss from the amount of bonus payable by him to the employee under this Act in respect of that accounting year only, and the employee shall be entitled to receive the balance if any, that is minimum and maximum bonus payable. We have to understand the minimum bonus is the minimum bonus which an employer is required to pay even if he suffers losses during the accounting year or there is no allocable surplus is 8.33 of the salary during the accounting year. See here, on the part of an employer, he has to face two important conditions, that is, one is set on and set off. So this bonus, as we have understood, it is some additional remuneration that is being paid for the worker's performance, for his good performance, or maybe because the employer has obtained some profit. So on that basis he has to pay the bonus. So suppose imagine in any one particular year the employer has not got any profit, then he cannot be away from paying the bonus. So the reason is again two important conditions, as he can claim that, or he can say that the bonus can be paid in future, that is he can postpone the payment of bonus but he cannot cancel the payment of bonus for any particular year. So that is again he is obligated to pay a minimum of 8.33% of the profit he obtains, and rupees 100 in case of employees above 15 years and rupees 60 in case of employees below 15 years, whichever is higher, to them it has to be paid, and a maximum bonus of 20% has to be paid, where the bonus amount, it won't exceed more than 20% of the salary of the worker. So as already we said, a minimum of or maximum salary for the entitlement is 10,000 per month, and minimum is 3,000 per month. If in any accounting year the allocable surplus calculated after taking into account the amount set on or the amount set off exceeds minimum bonus, the employer should pay bonus in proportion to the salary or wages earned by the employee in that accounting year, subject to a maximum of 20% of such salary or wage. So these are the important conditions that they have to meet. Now let us understand time limit for payment. The bonus should be paid in cash within 8 months from the close of accounting year, or within 1 month from the date of enforcement of the award or coming into operation of a settlement following an industrial dispute regarding payment of bonus. However, if there is sufficient cause, extension may be applied for. So with proper reasons, an extension can be applied to the labor officer or the labor officer appointed by the government. To them he has to submit. And calculation of bonus includes, based on the available surplus, the calculation includes, so available surplus is gross profit minus, we have to deduct the depreciation admissible under section 32 of the Income Tax Act and development allowance, and available surplus deductions where direct taxes payable for the accounting year calculated as per section 7, it sums, that is the sum specified in the third schedule, and direct taxes calculated as per section 7 in respect of gross profits for the immediately preceding accounting year. And again we can calculate the allocable surplus if it is 60% of the available surplus and 67% in case of foreign companies. And again they have to make an adjustment for set on or set off, as already discussed, for calculating the amount of bonus in respect of an accounting year. Allocable surplus is computed after considering the amount of set on and set off from the previous years as illustrated in the fourth schedule. Say for example, if the employer has requested or has claimed to pay the bonus for the next year, so because of not the deficiency or for not getting the profit this year, so again in the next year, along with the profit of that next year plus the previous year's the balance, he has to compute, and that has to be paid as bonus. So this is set on, and set off is by default they have to pay whatever may be the profit, so or loss. So whether he got a profit or loss, he is entitled to pay for the bonus. And now let us understand these two conditions, that is set on and set off, because these two are important concepts that we have to understand under Bonus Act, and this may be asked for the exam also, for maybe for 3 marks or for as short notes. Now let us understand what is set on, where for any accounting year the allocable surplus exceeds the amount of maximum bonus payable to the employees, then the excess shall, subject to a limit of 20% of the total salary or wages of the employees employed in the establishment in that accounting year, be carried forward for being set on in the succeeding accounting year, and so on up to and inclusive of fourth accounting year to be utilized for the purpose of payment of bonus. And set off, where for any accounting year there is no available surplus or the allocable surplus in respect of that year falls short for the amount of minimum bonus payable to the employees, and there is no amount or sufficient amount carried forward and set on which could be utilized for the purpose of payment of the minimum bonus, then such minimum amount or the deficiency as the case may be shall be carried forward for being set off in the succeeding accounting year, and so on up to and inclusive of the fourth accounting year. So these are the important conditions. And now let us understand the duties of employer. The duties includes to calculate and pay the annual bonus as required under the Act, and to submit an annual return of bonus paid to the employees during the year in Form D, and to the inspector within 13 days of the expiry of the time limit specified for payment of bonus, to cooperate with the inspector to produce before him the registers, records maintained, and such other information as may be required by them. And the rights of the employer includes right to forfeit bonus of an employee who has been dismissed from the service for fraud, riotous or violent behavior, or theft or misappropriation. Like this, already we had discussed this. And rights of the employees, again the right to claim bonus payable under this Act within 1 year, and suppose if any deviations with respect to payment by the employer, he has to face the penalties, or case can be filed as an offence with a fine of up to 6 months of imprisonment or fine up to ₹1,000 or both. So these are the different conditions the employer has to meet under Bonus Act of 1965.